Hello, everybody. We might get started. So my name is Alexandra Phelan, and I'm an associate professor in planetary and global health law at the Johns Hopkins Bloomberg School of Public Health and faculty director of policy at the Johns Hopkins Institute for Planetary Health. I am delighted to welcome you all to our panel today on planetary health law, legal innovations for a thriving planet. We have a truly exceptional group of speakers today. They are each leaders in their fields who are at the forefront of examining the vast role of law as a tool or a barrier to address threats to global and planetary health and to address inequities and injustice in the distribution of environmental harm. In our panel today, our speakers will take us through legal successes and challenges from the community to the global levels, and from the very tangible to the conceptual, considering what planetary health approaches offer law for a reimagined future. I will introduce our first four speakers in turn, as they each then provide their remarks. We will then have time for audience questions and answers from the panel. If you ask a question using Slido, please, if you feel comfortable, I do invite you to introduce yourself and where you're from, along with your question. Following Q&A, I will then introduce our final speaker, who will provide reflections on the panel and lessons from their experience as an advocate in one of the greatest global health and equity challenges of recent memory, and where that can take us next. So, to begin our panel, we are very fortunate to have Dr. Arpitha Kodiveri joining us virtually. Dr. Kodiveri is an assistant professor of political science at Vassar College in New York. Her work focuses on the role of law in redressing harms faced by Indigenous communities in South Asia. She has previously worked as a legal scholar and an environmental lawyer on land conflicts and legal mobilisation by forest-dwelling communities in India. Dr. Kodiveri is the recipient of the Hans Kelsen Fellowship at the European University Institute, as well as the Fulbright Nehru Fellowship. Dr. Kodiveri, the floor is yours.
Thank you so much, and it's lovely to be here. I wish I could have joined all of you in person. It's a bit early, and I'm on my first cup of coffee, so do be gentle in terms of expectations. But I will basically be speaking to my experience around heatwave litigation and the lessons that I have learned through that process, and the challenges that have been building along the way. So it's a bit of an insider's perspective, as it were, on what the possibilities and challenges are. I hope you can see my screen.
Yeah, we can see it now.
And as I describe this journey, I also want to kind of state up front that a lot of this exploration has been about trying to see how litigation can assist communities, particularly in South Asia, who are in some sense experiencing a double whammy with both heat waves and inaccessibility to climate litigation. And it's interesting. So heatwave litigation as a genre or a category of climate litigation has been there, but hasn't been fairly pronounced, one can say. So these are just like a sampling of some of the big cases that get spoken of within the climate litigation space. The Multnomah County case is interesting because it takes on big oil and actually a consultancy as well, McKinsey, for the 2021 heat dome in Portland, Oregon. And the argument it makes is one of product liability, that big oil was actually selling fossil fuels without communicating the impact that it was having on climate change. And it's an interesting case not only because it looks at corporate accountability, but it uses heat waves as you read the complaint and the petition, mainly because attribution science, which is one of the foundational ways of building legal evidence for climate lawsuits, is very accessible when it comes to heat. The other famous case that gets spoken of is the Swiss senior women's case. And this is an interesting case because they go after the state for mitigation on the basis of health impact for older women. And both of these cases are just sort of the emerging typologies of heat wave litigation. But the one that often stands out to me is the one that the Rajasthan High Court took suo moto notice in 2024, actually, where it says that these extreme heat waves are impacting citizens and the state is doing nothing. So it actually goes into detail to talk about providing cooling centers and speaks to the right to a healthy environment as well. And so these are the sort of, not only are these the emerging typologies of litigation, but as many of us know that the wave of climate litigation is now in kind of its third era where it's looking at loss and damage, or how can communities access climate compensation for a lot of the harm that's being experienced. And so, with that in mind, I set off to Bangladesh with the idea of building a climate case from the ground up. And this was an interesting experience because the group that we were actually collaborating with and the communities that they were working with were primarily concerned with sea level rise. But there isn't sufficient climate data, and attribution science hasn't evolved to a greater extent when it comes to sea level rise to be able to tell that chain of causality between adverse climate harm to climate liability of a particular corporation. So that's the arc that needs to be completed by attribution science. And heat wave, on the other hand, is more accessible and available as an option. And so we had this strange experience where we had to go back to the community and say, we know you're concerned with sea level rise, but we're unable to prove that in court as easily. Thus, let's sort of go the heat wave route. And so I think that with this kind of accessible framework that heatwave provides and the broad scope of impact that it's able to showcase is only going to make this particular arena of litigation more popular in the near future. So I want to quickly kind of go over some of the possibilities and the inequities and the role that health as legal evidence becomes key over here. As I mentioned, legal evidence around heat waves is more accessible. There is, of course, a climate data apartheid that exists in the world at the moment, with Global South not being as climate data rich. So something like heat becomes much more easier to not just access data, but to show adverse impact and link it back to climate change. The other interesting aspect is that it requires the use of health as legal evidence, but that has been a much more trickier question. Because on the one hand, there are categories of vulnerability that can, through studies, show that older women, and pregnant women are more impacted by heat waves. But heat-related deaths are very, very difficult to prove because none of those deaths get recorded as, the reason behind it being heat strokes or such. And this has been a huge issue that even the Indian courts have been trying to resolve. The other sort of, I know I was supposed to talk about possibilities, but I'm talking about possibilities with a good dose of the challenges as well. So the ground to the right to a healthy environment, especially after the ICJ advisory opinion and this, the General Assembly resolution, has become a new fertile ground to talk about this. But again, that evidentiary barrier is something that we still have not been able to overcome. The other challenge that remains is holding corporations accountable because very often these cases get, there's a counter litigation that tends to happen, say, in an investor dispute resolution process. And I'm happy to speak more to that in the Q&A. But I want to conclude by the kinds of inequities that litigation produces. And I think one caveat, or rather one observation I have, having been in the field of climate litigation, is that very like early days in, as an environmental lawyer working with indigenous communities, you often thought of litigation as the last stop. You tried every other legal strategy and then you eventually sort of go to litigation as the last resort option. But here we're sort of starting with strategic litigation as the point of beginning. And so that really changes the way in which legal mobilization gets shaped and how it kind of prioritizes certain categories of vulnerability and types of communities who get represented in these cases. As I mentioned earlier, I think heat wave litigation based on access to health-based evidence has allowed for certain voices to be heard in terms of categories of vulnerability and others not. Whether it's, looking at construction workers as opposed to older women. And this is not to pit one community against another, but to showcase the reality of how the law is unable to capture the diversity of communities impacted. The second is this idea that I borrowed from Sangamitra Padi, where she talks about this notion of thermal justice, where bodies in the global south are seen to have or are viewed as being more adapted or capable of dealing with the heat than bodies in the global north. And even the first wave of heat wave litigation has been concentrated in the global north as opposed to the global south where we see more impact. And so there is this idea innately within this notion of thermal justice, which is some communities deserve sheltering from the heat and others don't. So whose body and whose heat, and what do we mean by vulnerability and legal shields and protections? Lastly, as I don't want to go into this even more, but the evidentiary barriers remain. But I do think that there's something interesting that's happening where litigation is pushing for local bureaucracies and other organizations to actually record heat-related deaths. But it's sort of a chicken and egg question. What comes first? Should we litigate and then proceed to actually understanding health impacts, or the other way around? And I think to conclude, despite being well embedded in the field of climate litigation, I'm often questioning if the future is one where we continue to litigate these harms, or will there be a cascading effect of a couple of precedents that will, shapeshift and change the legal landscape? And that's something we'll have to wait and watch. But I'll stop with that. Thank you so much.
Thank you so much, Dr. Kodiveri. It's wonderful. I want to now turn to our next speaker, and it's Professor Michele Goodwin. Professor Goodwin is the Faculty Director of the O'Neill Institute for National and Global Health Law and the Linda D. and Timothy J. O'Neill Professor of Constitutional Law and Global Health Policy at Georgetown University Law Center in Washington, D.C. Professor Goodwin is an acclaimed bioethicist, constitutional law scholar, and a leader in defining the field of health law. You may know her from her public advocacy and as host of Ms. Magazine's On the Issues podcast. Dr. Goodwin is also a prolific legal scholar. She is the author and editor of 6 books and winning national awards for excellence in her scholarship, teaching and community service in health law, bioethics, and civil and reproductive rights, including the American Bar Association's Margaret Brent Women Lawyers of Achievement Award. I'm so delighted that Professor Goodwin is here with us today. The floor is yours.
Thank you so very much. That's quite the generous introduction. And it's a pleasure to be here with my co-panelists. And the presentation that we've just heard is so incredibly important, and I want to build on it in my brief remarks here. So I think it's important that we take to the stage and understand a framework of trade-offs and those who have and those who don't have as a start. And as part of that start, also understanding that the framework for ethics and the inclusion of bioethics as a framework as we think about environmental justice, planetary health is critically important. We have come through a space where we understand through international tragedy the importance of a bioethics framework. The modern day bioethics framework is one that is built upon from the tragedies of Nuremberg. And I think it says a lot just in starting there. So many people think about Nuremberg and they see it as one element of prosecuting heinous crimes carried out by a government, and they think about that within its political space. Many people do not understand that there were two trials at Nuremberg, one that involved government officials and guards, etc., but there was another one that involved doctors. And here's where the complications of how we understand law and legal policy are so incredibly important. The persons who led the prosecutions there came from the United States, and one of them from the United States Supreme Court, Justice Jackson, who left the court for this purpose and served as lead prosecutor. And what was fascinating about that, and I think it says a lot in terms of setting the stage of the complications of the spaces that we occupy, is that there was an affirmative defense. And for the lawyers in the audience and those who are not with us in person, we understand an affirmative defense as being that which you say, well, you can defend against this harm because there's some other principle that was being affirmed. We think about that, for example, with something like self-defense, this idea that a harm was created, but it was in response to something else. Well, it's a bit ironic that there would be doctors who would even have an affirmative defense given all the heinous things that had taken shape there. But their affirmative defense related to things that were taking place in the United States, that they said, well, how could you prosecute us when we were only following what you do in the United States? And quite specifically, what they were talking about is 1927, the United States Supreme Court, this very Supreme Court that Justice Jackson had served on, upheld a Virginia law that provided for compulsory sterilization, or otherwise what we know as eugenics. So it was in 1927 that the United States Supreme Court reviewed a Virginia law and said that the law was actually constitutional. This law provided for the compulsory sterilization of individuals who were considered unfit, unfit being broadly undefined. Anything could make you unfit so long as you just didn't fit in with what the state thought you should be, whether you were too poor, whether you had a family background of disability, or whatever it happened to be. And this law, this model law out of Virginia, became the platform for eugenics in the United States in more than 30 states, but it turns out that the Germans also thought that that was nifty as well, and quite interesting, 1927. And the date is worth noting because World War II happened so long after that, meaning that the United States was engaged in a practice for quite a while before the Germans said, we can do that too, and that looks very interesting. And we'll visit the United States so that we can see how you apply it. And we'll do it like you do it. And so then there is Justice Jackson saying, well, we'll prosecute you, and the doctors saying, but we did it how you do it. We've seen what you do. And so when we think about just starting off, it's really important that we're just honest about what it is that we see and the trade-offs that have taken place, the things that we have that are close to us, our cell phones, our laptops, computers, all of these various things that we demand and that we need, and now that have been even translated to the levels of children, that the children in their schools, to be properly educated, need these tools, right? The laptops and whatnot. But there are trade-offs, aren't there, in terms of what are the communities that pay the cost of the mining such that the components can be used to put into these various kinds of things that we say that we need. And that's important for us to understand. That which was considered as a luxury, now that drills down and seems like a necessity, and where is it being mined and pulled from? So then we think about the extractive economies of what's taking shape throughout the continent of Africa. It's a continent, not a country, but certainly countries within that continent being significantly affected by the things that we say are really important for us and important for our environment, right? So you think about electric cars. Well, where are the components being extracted from? And then what does that mean geopolitically within those spaces? And thinking about a place like the Congo, and how do we translate that? We think about the extractions taking place in the Amazon and what that means. And when we think then about vulnerable communities and the communities that pay the price for our modernization, and it's all within a flow that we have to think about. And for me, I think it's important to look beyond the US navel gazing, because so often when people from the US are on the stage, everything is just about the US, and I don't want that to be the case, so I want to think more globally about these issues, but it is true that the very kinds of concerns that are taking shape, the extractive economies from around the world, also have their effect in the United States too. We have communities known as cancer alleys. The cancer alleys predominantly are where people of color live. In fact, in the United States, the majority of the spaces where there's the greatest level of extraction but also dumping happen to be in places where there are people of color, high concentrations, and almost exclusively the people who are the poorest in the United States pay the cost for our waste and our waste dumping. And then you see that in terms of what it interrelates in terms of health. High rates of cancer, high rates of maternal mortality, high rates of maternal morbidity, high rates of infant mortality, high rates of infant morbidity. And you see a kind of political connection that is really critically important that we understand, because in these very same places, it's kind of like the people who are most hurt and affected by the environmental neglect also happen to be disempowered in other spaces too. Politically disempowered in ways that you just see such the harms that are inflicted on their lives quite explicitly. And we can see that if we draw Venn diagrams in the United States. The same communities that are suffering from maternal health, from infant health, from being politically dispossessed, from the policing of immigration and whatnot, they all kind of follow in the same kinds of Venn diagrams. And I think that there's much for us to learn from that. So let me just turn to the following in terms of thinking about how we want to think about what happens next. I mean, typically, as we approach matters of environmental law, there's been this notion of the five platforms, right? Thinking about matters of regulations, statutes, policies, treaties, and conventions. And I think that all of those legal frameworks are critically important, but I think that we can't remove from that thinking about matters of enforcement, particularly in politically vulnerable and dire times. So we can frame law, but law is only as powerful as we're willing to commit to it, only as powerful as we're willing to enforce it, only as powerful as everyone joins in together and we just simply don't burden the global south or the more vulnerable economies in terms of bearing the cost of what we want to do to protect our environment. And I think that that's the sort of critical obstacle that we have when we think about the environment, environmental justice, global health, and the various framings, because we can use a variety of ways of planetary health. There's so many linguistics that we can use for basically what we're all here for. But the biggest vulnerability is living beyond the paper. And I think that that is our challenge. And I think that there's been tremendous commitment from countries around the world, but one in which there's been also a tremendous impediment happens to be where I come from, the United States. And its inability to stay consistent within a commitment to environmental health. And this gets us back to trade-offs and competition as I begin to wrap up, because of this tremendous demand from industries, and industries competing then again with platforms for protecting health. And what we've seen over time is industry having a significant thumb on the scale. And it doesn't have to be one or the other. It can be collaboration. But that's not necessarily been the approach that's been taken in the United States. And we see now with the weakening of global cooperation, while there's global cooperation from outside of the United States, within the United States, that commitment is not consistent. Is not to say that there aren't states that are willing to engage. The federal government right now is showing a lack of commitment within these regards. And so then one has to look to the state level to respond. And that's a space of hopefulness for any number of things. But it is incredibly disappointing that U.S. federal government and U.S. federal policy is more in a space of decline and retrenchment in this regard than forward. And the last thing that I'll say about this is the very complication when there are even the terms that we're using within this meeting as being banned in terms of being spoken by state governments. So we have certain states that say, well, if you're an employee in that state representing the state, then you may not use certain terms like global warming, climate change, things like that. So how do you address these concerns if, in fact, now what has been censored from even the ability to speak and to say these words that are so critical? So I'm happy to be part of this conversation. I just wanted to put out a few of those matters just to table set a bit, and I'll just conclude with saying that as we think about the communities that potentially stand to be most harmed if we don't grab a hold and really take care of these issues, happen to be the most vulnerable in our societies. These are people who are elderly, these are women, these are children, et cetera, and we really need to pay attention to that as we create intersectional thinking about these concerns. Thank you so much.
Thank you so much, Professor Goodwin. That leads us very nicely into our next speaker, that idea of translating what is text and on paper into enforcement. And I'm really excited to introduce a local star. Dr. Marlies Hesselman is an associate professor in the Department of Transboundary Legal Studies and chair of the Groningen Centre for Health Law at the University of Groningen here in the Netherlands. Dr. Hesselman's research and scholarship is at the intersection of international human rights and climate law, with a particular focus on energy justice and access to modern clean energy. Dr. Hesselman is academic lead for Planetary Health at the Aletta Jacobs School of Public Health, and she's chair of the Planetary Health Working Group for the Global Health Law Consortium. She was founding co-editor of the widely cited Yearbook of International Disaster Law and previously held several positions within government and the NGO sector, including at the Netherlands Ministry of Foreign Affairs. Dr. Hesselman, the floor is yours.
Thank you, Alexandra. And yeah, I'm very happy to be here on this final day of the conference, being able to speak about the role of law, the power of law in planetary health. I was quite impressed and happily surprised myself that during one of the first main panels, the word litigation was mentioned a number of times. We are not always used to that as lawyers coming into interdisciplinary spaces. That our field is immediately recognized as being relevant. But I think for planetary health, because its global dimensions, because the need for strong cooperation between states, but also strong support from society, law is inevitably vital. I would want to speak to you a little bit about a number of legal innovations that have recently occurred over the past year, some even last week, in the area of international human rights law, or specifically from the area of human rights, where I want to put on the table that human rights, despite its also anthropocentric focus, is a very important framework for action on planetary health, an important site for struggle also for planetary health. And like I said, even despite this anthropocentric focus of human rights, because it's also sometimes critiqued as a framework for being very human-centered only. Human rights are about protecting human beings, but of course we should not forget that it's of course about the rights of all of us, but specifically also of those that are most marginalized and vulnerable. And what we are seeing with these legal innovations of the past year is that human rights law has increasingly found a way to speak to planetary health threats, and that the ideas of planetary health are increasingly seeping into the legal framework and getting legal form, whereby they may also become a part of enforcing rights and enforcing action for planetary health. So maybe before I give these three examples, I also briefly wanted to highlight that using human rights in the area of environmental protection is not new. There has been a long tradition of environmental rights, maybe even dating back to the 70s, whereby we have an understanding of how human rights are dependent on the health of our environment, but also how human rights can be mobilized by the public to call for better environmental protection. And that has been done through a lot of existing human rights, such as our right to life, our right to health, the right to clean water, but increasingly also to specific dedicated rights, such as the right to a healthy environment. And unfortunately, in some ways, we have only just recently seen the endorsement of this idea of an international right to a healthy environment by the UN General Assembly several years ago. The UN was relatively late to the party in that sense, because environmental rights had already been adopted in many national constitutions worldwide, including in many global south countries. So this is really also an idea that comes up from the bottom, from countries where these issues play a role. But international law now endorses this idea of a right to a healthy environment, if perhaps not as an innovation per se, at least as a major milestone that we now try to understand what that means in practice. And these three recent developments of last year that I will talk about are about this right to a healthy environment, but also how civil society, human rights bodies are already both pushing that concept into something that really responds to planetary health concerns, but also might lead to accountability. So the first innovation I wanted to talk about is the ICJ advisory opinion. So the advisory opinion of the International Court of Justice on climate change, which came out a couple of months ago. It was very well publicized in the news. I'm curious how many people in this room are familiar with this advisory opinion. Good, right? It is quite well known, and rightly so, because it was a major innovation in the area of international law, and certainly also in the area of human rights law, because the International Court of Justice gave a very strong statement in favor of the rule of law, but also specifically states individual responsibilities to curb climate change. And it did so with support of a number of areas of law, including international climate law, international environmental law, the law of the sea, but also human rights. And the opinion was celebrated by human rights scholars because it referred quite clearly to this idea of the right to a healthy environment. Although some of us have also been a bit critical because the court was somewhat conservative. It said, yes, this right exists, but it's very closely tied up with others. So we don't really know yet what specific meaning the court is actually giving to this right to a healthy environment in the context of this opinion. But we may be hopeful that interpretations become more robust, also progressive, because the court actually also did refer quite strongly to ideas of the right to health being important in this context, and also really the idea of planetary health being important in this context. It ended with an extremely inspiring statement that I think will be resonating also in other cases and in other legal developments around the world, where it really acknowledged that humanity is facing an existential threat of planetary proportions, right? It really said that this advisory opinion is about the protection of planetary health, and that this is really a crisis that needs to be confronted by the whole of society. The struggle can not only be fought in courts, it should be something that is really something that society works on as a whole. So from this advisory opinion, which is hopeful, is a good innovation, maybe a milestone, I want to draw your attention to another important innovation that also occurred the same year, a few months before, and that is the advisory opinion of the Inter-American Court of Human Rights. And now I'm curious, who has heard of this one? Is it similarly well known, or this is already a little bit more niche to the lawyers in the room? And that's a shame, because this advisory opinion from a regional human rights court, the Inter-American Court on Human Rights, has been highly innovative when it comes to endorsing the right to a healthy environment, what it means, tying it to planetary health. And I think this is really a good standard for how the right to a healthy environment might evolve, be implemented, be mobilized to really speak to planetary health. What did the court say? It endorsed this idea that our right to a healthy environment is a fundamental right and fundamental for the existence of humanity. It is tied to other human rights, and it is something that belongs to us individually, but there is also an important collective dimension of this right. And it says then this collective dimension has universal value for both future and present generations, and above all, this human right can be used to protect the nature, the components of nature and the environment as such. It also gives rights to rivers, to forests, to important ecosystems, to all the things that are important to helping humanity thrive and exist, right? So this is really moving beyond the anthropocentric definition of human rights. It's embracing a very strong ecocentric, ecological focused interpretation of what this right to a healthy environment is for and what it is about. What I find particularly interesting is that also this court really embraces planetary health language and the triple planetary crisis language. It acknowledges that it was asked to give an advisory opinion about climate change, but that climate change is not the only threat facing human rights. It is also about biodiversity. It is also about large-scale environmental degradation. It is about all the planetary boundaries that are at stake. So it really, I think, raises the opportunity for talking about this right in a much more holistic sense. It will now be interesting to see how this opinion is taken from the inter-American continent to other continents, to the global discourse. And we can all play a role in that. That's going to be one of my main messages. The third innovation that I wanted to draw your attention to is also quite unique. This is a very recent one. It only came out last week. So I'm sure that most people in the room have not heard of it. This is a new so-called general comment from the UN Committee on Economic, Social and Cultural Rights. This is a body that supervises the global implementation of the International Covenant on Economic, Social, Cultural Rights. And occasionally it gives out an important statement that clarifies what states must do to protect human rights under that treaty. And it has been working for a while on a comment that is about the International Covenant on Economic, Social, Cultural Rights and the environmental dimensions of sustainability as related to the rights involved. We had to wait somewhat for this general comment because it was quite hotly contested. There was pushback of states. There is some general agreement that the language on the role of fossil fuels is, for example, quite weak. There is affirmation of a lot of climate change objectives. There is affirmation of the right to a healthy environment, which will no longer be controversial because we have just seen a few strong advisory opinions on it. But what I want to note from this, this new legal document is that, again, we see the embrace of planetary health language, right? So the idea of the planetary crisis, I think, is really seeping slowly, and certainly the last year, into all these important legal developments, whereby human rights bodies are trying to understand what it means to protect human rights in this context. Amongst things, the right to health is one of the key rights that is protected by this International Covenant on Economic, Social, Cultural Rights. And the committee was able to give an interpretation of this right as it relates to planetary health. And it was very interesting to see that, again, going a bit beyond what was maybe traditional environmental determinants of health, thinking about clean water, thinking about the soil pollution, land pollution, air pollution, it's really going a step further. And it's asking for application of the right to health in the context of biodiversity protection, climate change, ecosystems health. So really these much bigger questions of planetary health that determine our human health. The committee also specifically said for the first time that implementation of the right to health requires an intersectoral collaboration that addresses the interrelatedness of nature, of humans and animals, and environmental health, and that is vital to promoting planetary health on which human health depends. And then it concluded with saying that this is a matter of civil society participation. Civil society should be involved in the planning for all of this. And I think that is also the statement that I want to end with, is that all of these legal innovations that I've just cited have arisen out of major struggles by civil society, about people concerned for environmental health, including academics. Many of these processes, these legal processes in human rights law, they are open to comment, to engagement from the public, including from academia. With the Global Health Law Consortium, for example, we have submitted a submission for input on the right to health, including as it relates to planetary health. And we can see the results of that in this new statement of law. So I would really almost extend a welcome to everybody in the room, even if you are a non-lawyer, to engage with these processes and to call out in favor of the importance of linking human rights with planetary health and the opportunities for doing that. I will keep it at that. Thanks.
Thank you so much, Dr. Hesselman. We're going to turn now to our fourth speaker online. Professor Eric Ip is a public health bioethicist and professor of law and co-director of the Centre for Medical Ethics and Law at the University of Hong Kong. Professor Ip's scholarship has pioneered the field of planetary health law with a forthcoming book on the topic from Cambridge University Press. His research focuses on climate crisis impacts on health and human rights, as well as comparative public law, receiving several outstanding teaching and researcher awards. His thought leadership is defining how we conceptualise planetary health, a planetary right to health, and I am delighted that he's able to join us virtually today. Over to you, Professor Ip.
Thank you, Alexandra, for that warm welcome. I'm very grateful to be here with this excellent panel. Thanks for joining me today. We face three major crises: climate change, biodiversity loss, and pollution. These put us at a key moment in history. The air we breathe, the water we drink, and the soil we walk on all need protection. So I call my presentation toward a constitution for planetary health. I see law not as dead rules, but as a lively tool. It can build a stronger, more connected system of institutions that can keep Earth healthy for all of us. Bad laws, of course, have made the planetary crisis worse, but this was not always true. Let's take a look at history. Think of England's Charter of the Forest of 1217, came from ordinary people fighting a greedy king. The Charter said forests, rivers, and open lands belong to the community, not just to the king. It set rules for sharing these places. People could collect wood, pick berries, or let animals graze, but without destroying the land. This old document linked human lives to the health of nature. It started a way of governing that still matters today. Fast forward 800 years later. The 1972 Stockholm Declaration connected human rights to a good environment, and it started global actions. And the latest big step came in July this year. On the 23rd, the International Court of Justice gave a strong advisory opinion which said that a clean, healthy, and lasting environment is basic for life. It is key for health, good homes, and enough food and water. In fact, this right is already now in the constitutions of more than 160 UN member states. It allows communities to sue big polluters in court, and law has grown from local agreements to global promises. This shows that law can lead us to a healthier planet, but only if we can, but only if we allow it. But here's the problem. Our international laws for planetary health look good on paper, and yet they are badly divided, weak, and fractured. Imagine trying to stop a big fire. You grab cups from different kitchen drawers. Each cup works for only one kind of fire. That's exactly our situation. The UNFCCC deals with climate change. The Convention on Biological Diversity protects different plants and animals. They aim for small wins like lower emissions or saved habitats. Then, separate from international environmental law, the WHO Constitution, which functions as the centerpiece of global health law, focuses on human problems. But it often ignores the environmental causes of such human health problems. For example, polluted air causes more asthma. The loss of habitats leads to diseases jumping from animals to people. The groups in charge make it worse. The UN Environment gives advice on environmental issues. The World Health Organization fights sickness, but they carry out their work in largely separate and uncoordinated ways. Teams pull in different directions. Human-centered views, meaning anthropocentric views, chase fast money over lasting health. And threats like animal diseases to humans often go unnoticed. The One Health idea in the 2025 WHO pandemic agreement was a good start. It encourages work across groups, but it is only a small bridge. We need full unity, not quick fixes. We must connect everything. This division leads to the main question. Are there any basic rules for a rights-based planetary health approach? This means joining two key paradigms in one: the right to a healthy environment and the rights of nature. We build one structure that respects Earth more than humans rule it as it is. The right to a healthy environment, as I said just now, is already in over 160 national constitutions. And the ICJ supported it this year, finally. So it's no longer a high dream. It is the base of our dignity. It links clean air and safe water to our chance to live well. Now, add the rights of nature. In Ecuador's 2008 constitution, Mother Earth has rights to exist, continue, and be healed. And in New Zealand, as depicted in this photograph, when Goodwin River has legal personhood, it is seen as a living family member of the legal community. So these are not just nice ideas. They break the old thought that nature is only for taking. They make humans part of life's big web, guided by rules that put the planet at its natural foundations first. So what does this mean? It flips the legal view, the traditional legal view. It puts whole ecology first, not endless taking of resources. It uses the precautionary principle, and of course also the prevention principle, and common but differentiated responsibilities. And they are supposed to help poorer countries or those in the global south to adapt. But this right way follows the UN's core: peace, dignity, and equality on a healthy planet. It gives us the duty to it gives us the duty to guard nature instead of controlling it. It fights unfairness, it takes indigenous knowledge seriously, and for groups hurt mostly by poisons and waste, they will receive adequate compensation and healing. To make this happen, we need groups that join these ideas and act on them. Let us think wildly, with some imagination, despite what's currently happening in the world. What if we combine WHO and the UN Environment Programme into something like a planetary health organization? See it as an organization that, just like WHO, can make treaties. Money comes from funds or green bonds, avoiding control by big donors. The PHO can even link or bring together diverse agreements such as the Paris Agreement, the CPD, and the Pandemic Agreement of 2025 into one overarching framework. Using a WHO-UNEP coalition on health, environment, and climate can fight 12.6 million deaths each year from environmental risks more effectively. Remember that international environmental law and global health law as they currently exist lacks teeth. To add strength, would it be possible to join the PHO with a Planetary Health Tribunal, or PHT, which works as a special court like the existing one for sea law? Half of the judges can be ecology experts or planetary health experts, half are legal experts. This body can potentially solve fights between countries, companies, and local people, or at least standardize the interpretation of planetary health law for better guidance. Tools could include fines, payments for harm, and also the appointment of guardians for nature. The PHO can be the legislator, and the PHT can make rules work through interpretation. A strong team for true duty, and they might even need a better guide in the form of something like a framework convention on planetary health, a strong agreement that joins the basic rules together, which says that the right to a healthy planet is not only linked to human rights, but also to the rights of nature or the rights of the planet. However, we must always remember that the law can't solve every problem. We shouldn't be superstitious about the power of rights and law. So even with all of the above reforms, problems may still persist. The fears of losing power from big countries, such as the United States or China, or low resources in the global south. But I think there is still hope. In the end, the Anthropocene is not really the end. From the Charter of the Forest to the ICJ's 2025 opinion, the law has balanced human good with the Earth's heartbeat. The Planetary Health Constitution, whether it is codified or not, whether it's made real by a planetary health organization or planetary health tribunal, or something along these lines, might be able to fix our splits. It asks humanity to see ourselves not as above nature, but as part of our planet. Thank you very much.
Thank you so much, Dr. Ip, for giving us a vision of the future and imagining. And I think legal imagination has been such a core part of so many collective action issues throughout history that it's exciting to think about when we see a PHO or a tribunal in the future. Remember Professor Ip's talk today. We're going to turn now to a little bit of Q&A, and I wanted to, there's been quite a few questions that have come through on the Slido that I thought I might sort of bring together a little bit. And a common question that folks have, and David, please feel free to jump in here, even though I haven't introduced you formally yet, or add it into your remarks. But a common question that folks seem to have is around the idea of enforcement. And I think that's particularly alive in people's minds right now with the current many different crises happening around the world. But this idea of, how does enforcement occur? How can we have enforcement? And what do we mean by enforcement? Whether it be at the local to the international, whether we mean normative or... so I would love to get your thoughts. Can I start with you, Professor Goodwin, before turning to our speakers?
It's a great question. So the first prong of enforcement often means that there is a body, an individual or a group that has recognized the harm and then brings it forward. Well, that has many questions too, right? So usually that involves needing resources to be able to do that, to be able to have the legal support to be able to do that, and that's a cost. Just as a first start, after you've recognized the harm, to bring it forward. And then there's the question as to whether the harm can actually be remedied. In many contexts with regard to environmental protections, it's because there has been some form of a law of some sort that recognizes if this harm exists, you then may be able to litigate and then from there bring it forward, and that's no guarantee of what the outcome will be. But if the very platform or law that used to exist that says we recognize this harm, and if you do too, then you can bring this. If that law goes away, such as what we see in the United States with certain erosions or pullbacks of certain laws, then that pretty much handcuffs and shackles individuals from being able to come forward. And it is really worth noting that it can cost to do this kinds of litigation. You have to pay people, or it is that if it's not paid for, that at the end, it's a government that will compensate back. So it's not easy, let us say. I think that that's the first part. And then the second is that even if there is some legal victory, that is to say that there's been a wrong that's been identified and now there has been litigation to resolve that wrong, and there's been a body that says now you must comply and fix this wrong, then you have to rely upon or hope that the entity, the state, that's responsible now for coming and doing it will actually comply and actually take care of what now they're legally obligated to do. That's also a bit of a challenge because it doesn't necessarily mean that that will take place. One last thing I'll say and then pass along the microphone is that there are different kinds of remedies that can be sought after there has been a wrong that's been identified. It can be now just fix the wrong. It can be now compensate others. They help to decide. And those are all things that we should think about. And in fact, I think we should be spending far more time in terms of thinking about what are the kinds of alternatives to what we've traditionally seen in terms of what enforcement could actually look like and what remedies could actually look like. What's the innovation space there beyond you all clean it up or you pay us and we have somebody else clean it up? What does that look like? And I love exactly what you were talking about in terms of the intersectional human rights framework, because I think that that's critically important. I'll just pass along the mic.
Thanks, Michele. That's indeed an excellent segue, because I was going to say that from a human rights perspective at least, and also if we see that in a wider international law perspective, human rights are uniquely the source of law that allow individuals and civil society to claim rights and to claim enforcement of law. We have very limited options for enforcement of international legal arrangements under a lot of other international law, which is mostly between states. So states would have to sue each other, but that's always a bit more sensitive. Human rights law, per definition, allows people to approach courts, supervisory bodies with their rights in hand, and increasingly complaining about environmental damage, planetary health damage, climate change. And this is what we're seeing all over the world at national level, regional level, international level, specifically through the form of climate change litigation, for example. This is an area that we work on a lot in Groningen at our Groningen Center of Health Law, whereby we have seen that with human rights in hand, people have won very important successes. An important landmark climate change has actually come out of the Netherlands, the so-called Urgenda case in 2015. It was one of the first cases where citizens really went to court with human rights in hand, saying government is not doing enough on climate change and it's violating our human rights. It has to do more. And the outcome of this case was successful through all three stages of courts that they had to go through. The court said, yes, this is about human rights. It's not a political question. Human rights are legal rights. They are minimum standards, and courts can enforce them, and they can test whether states are doing or not enough. Of course, in tandem with evolving climate science, involving global consensus on what is needed to tackle climate change. And the Dutch court said, you have to do more. And as a result, and this is, of course, a major challenge, we don't always know how states and governments are going to react to judgments. If rule of law is working well, if democracy is working well, states should respond. In the case of the Netherlands government did respond. And for a while we had the most ambitious climate target in Europe. And then in Germany, a similar case started occurring on similar grounds. And it was won successfully, and Germany became the country with the most ambitious target in Germany, in Europe. So we see that in Europe, these types of cases have had great success. We also see successes similarly in Global South countries. It also may be depending on what is being enforced. The Dutch agenda case was about asking for a better target. But we have a PhD student in Groningen from Indonesia who is comparing Dutch and Indonesian climate change litigation. And she's noting that when Indonesians go to court, they are able, and they also tend to ask for much more specific things. Please institute a climate change commission to help implement this plan. Please have a national action plan. And of course, that requires much more from the government to respond to specifically. And she's studying how that is working in an Indonesian context. The final thing maybe I wanted to add for consideration is that, yes, when we think about law, we think about legal enforcement, of course, through courts, through legal mechanisms. But I think in the human rights space, we often also talk about accountability. And then legal accountability is just one form. Being able to go to the courts and claim your right as law. But there's also political accountability. There's also social accountability. And in all these spheres, people can call upon international human rights norms, treaties that states have committed to, legally binding obligations. They must implement them. So even if courts are not available or accessible or temporarily not functioning well, wow, this is the moment to think about all these other forms of accountability. Final thing maybe I will add briefly is that in the area of climate change litigation, we also see a lot of strategic litigation, right? Human rights, not just as enforcement, but as narrative, whereby many civil society actors have gone to court, not in the expectation of winning, but in the expectation of educating the public, showing where there is a gap, showing where the law is not working. And that can be equally powerful as winning a case, especially if you prepare well beforehand on the negative outcome. Right? And then occasionally there are surprises, like in the agenda case, where you actually win and it has even bigger effect. Right? So I think there's many ways of thinking about enforcement, many ways of which law can play a role, and also, frankly, should play a role because they are binding standards. Yeah.
Professor Kodiveri, can I turn to you if you have any comments about enforcement?
Sure. I think much has already been said. I think a couple of things that I would add to what's already been shared is one of the challenges with enforcement around climate harm-based litigation is that it tends to shift the burden back to the plaintiffs to push for enforcement. And this is something that I often wonder about, and I don't know if I have a completely thought out answer, but especially around ideas of loss and damage and climate compensation, what happens after a progressive legal pronouncement? Does the burden shift back to communities to have to prove vulnerability in order to access compensation? I've kind of seen that play out in issues of large-scale environmental harm and toxic tort-based cases where communities have to then, there's an entire bureaucratic burden that gets shifted onto these communities to show health records and, create an entire file to be able to access a measly amount of money. And so that becomes a big question around enforcement. How do we create equitable modalities for enforcing? And as sometimes I think that, I think what was shared by the previous panelist of thinking of enforcement in a wide spectrum kind of approach is really key, because sometimes enforcement does not require litigation. Sometimes it requires bureaucratic conversations. So one can actually see that in the context of heat waves, where in countries like India, communities have started to paint their roofs white as a way to reduce the temperatures. And so there are these sort of, you could say street level bureaucratic solutions that are emerging, and the enforcement requires much more of a local bureaucratic based approach for enforcement. And that kind of bottom-up approach can actually inform policy as well. So to think of enforcement as something that's coming ground up, easily accessible and scalable, and not as resource intense, I think is a fascinating future that I see, at least around questions of heat waves and climate harm.
Thank you so much. I just want to give Professor Ip the opportunity if you had any remarks about enforcement.
Thank you. I'll confine my comments to international courts. I think we must all accept the reality that international courts like the ICJ operate without a global police. In other words, they function more like referees in a voluntary game where enforcement relies on indirect incentives and pressures instead of direct sanctions. In my view, the most powerful function of international courts is to provide stakeholders with a clear, authoritative, and standardized interpretation of certain fundamental legal norms affecting the health of the planet, so that it would reduce the difficulties of stakeholders in holding local or transnational actors undermining the health of the planet to account. Of course, these rulings can also benefit from the traditional desire of certain countries to safeguard their reputation and avoid isolation. But of course, not every country is that keen on keeping their reputation and avoiding isolation. But international court rulings, although they are not enforced by any global governmental armed force, could still empower NGOs and activists through their clear and authoritative statement of the law to exert pressure through further lawsuits and campaigns in regional courts or national courts. And finally, I think to improve on the compliance, the rate of compliance of governments and large companies with the right to a healthy environment and the rights of nature, innovative mechanisms can be developed, such as the appropriate use of artificial intelligence and machine learning to predict risks and enhance compliance monitoring in accordance with the interpretation set out by the relevant international court. And this could create a shaming effect even without traditional policing. So these are my current observations. Thank you.
Thank you very much. I want to tie together a couple of thoughts along with a question that came through based on the idea of an authoritative statement and the comments that Professor Kodiveri made about the science that is needed for the litigation, for strategic litigation. And one question here was, from Kaiso, was what type of evidence from the natural sciences is mostly needed to support litigation? And it makes me think about the role the IPCC played in the ICJ advisory opinion and the comments that you made, Professor Goodwin, about the impacts of restrictions on speech, about what sort of science can be conducted and the limitations we're seeing there. So what space is needed? What is the evidence that needs to be generated? And if I may return to you first, Professor Goodwin, to comment.
It's a great question, because at a time in which I put this back in terms of this tension between the state and then also individuals or bodies that would seek to get a remedy, to the extent that states have been involved in data analysis, in collecting information that then entities, public, could actually use with litigation, which is a great thing. in a way, right? The state is monitoring whatever it is, and then individuals are able to look at the data from the state and say, well, look, this harm still exists. Well, what happens at a time in which the state says we're no longer going to do that? We're no longer going to monitor these things. We're no longer going to report out on these things. And that makes it very difficult for individuals then who say, well, what used to be a clear water stream has turned green, brown, purple, and the state's no longer looking at all, collecting the data, then that's an added cost for whatever entity or community it happens to be. And as I've mentioned before, usually it's the most vulnerable, economically vulnerable, politically vulnerable, et cetera. Where do those resources come from? And then something that is taking place, to be clear, and that we should just simply name, there are foundations that are now being targeted, not all over the world, but certainly in my neck of the world, targeted for being involved in human rights, targeted for being involved in civil rights and civil liberties. So if the foundations no longer are able to provide the resources to community groups and to organizations, then it makes it very difficult. So that is such a great question. I'll pass.
Thank you. Yeah, that's an excellent question, Alex, and the audience. So again, speaking a little bit from my own expertise, specifically also on climate change litigation, I think what we've seen in the climate litigation space is that maybe also in support of lacking national data, or maybe in addition to national data, climate change litigation has so far been able to mobilize also the international science quite well. But that is because precisely there is so much effort and funding and resources put into it, getting it at this global scale and getting it also at a scale of consensus through the Intergovernmental Panel on Climate Change. So I think in climate change litigation, we actually see that there is already a lot of evidence that can be used from the IPCC, also from the World Health Organization. The Lancet Countdown on Health and Climate Change is moving into this area. So I think what we see in these cases is that this evidence is successfully mobilized. But if I speak from the European experience, what we see in the European context is a worrying trend a bit in climate change litigation, because we see that NGOs are able to quite successfully rely on evidence in the abstract. For example, I think it was mentioned by Arpitha, the climate litigation case by the senior women in Europe, the Klimasignorinen case, relied successfully on evidence on heat waves by the WHO, by the IPCC, etc. And it was accepted that an NGO could speak on behalf of a large group of of senior women. But there were also 5 senior women involved in the case themselves, with their own voice, with their own experiences, and they were rejected, in part because they had to prove even more harm, a critical medical condition, compared to what an NGO had to prove. That for me was already a bit of a red flag from a human rights perspective, if I'm very honest. But also, they had troubles proving as individual persons that their health was harmed by climate change. So we see, I think, at the individual level that there are some challenges. And at the Groningen Center of Health Law, we are very interested to try to see and work together also with public health people to see how this evidence can be improved. And as an additional layer on that also, we see increasingly people citing mental health impacts of climate change in these cases. This is even more difficult to prove, but I think an important next frontier. Yeah.
Professor Ip, did you have any comments you wanted to make on that question?
I've got nothing useful to add on this. Thank you.
Wonderful. Professor Kodiveri, can I turn to you if you have any comments on the scientific evidence question?
Sure. I think that, again, I feel like the panelists have done such a good job in capturing what's going on. I think the one element that I would add is it depends on the kind of case you're building. If it's a case where you're looking at questions of corporate accountability, the evidentiary barriers and the type of case, I mean, the kind of legal evidence you need to mount becomes more sophisticated and more targeted because it comes under attack, under heavy attack. And so if you look at the RWE case, where a Peruvian farmer went after a German public utility company, they kind of used this theory of contribution, where based on RWE's contribution to the global carbon stock, they were held liable to that extent. And it managed to go through the courts, and we know that a recent judgment came out of that case. So when we were trying to build a similar case, we had to rely on the same case theory and the type of evidence which was based on attribution science. And we kind of encountered a couple of challenges. One, as I mentioned, was the lack of climate data around sea level rise. So that was a big one. And so the choice of going the heat wave route. The second is the cost. So to hire a supercomputer to run those models is very, very expensive. And it just becomes more and more complicated because you almost have to hire a postdoc to be able to do the work over the course of a year. And I think the wait list to get access to that supercomputer is about 2 years, the last I checked. And so I just can't imagine the kinds of clients that I work with being able to afford that kind of legal evidence or being able to wait that long. So one of the things that we're trying to do is how do we democratize legal evidence around these kinds of litigation strategies? And how can we draw from earlier environmental justice cases? So how do we use testimony, citizen science, and other ways of making this argument? And that's where I think, as the panelists have mentioned, the right to a healthy environment is a promising potential legal ground, because I think health impacts perhaps might be easier to prove than the attribution science route, but I don't think we can ever get away from that. I think causation and attribution are going to be some of the, you could say, the prickly questions when it comes to the future of corporate climate litigation, especially around corporate climate liability litigation.
Thank you so much. So with the questions that we've explored, and thank you very much to the folks for putting them into the Slido, I want to now turn to our final speaker. It's my joy to introduce our reflection speaker, David Patterson. David Patterson has over 3 decades of experience supporting and advising international organisations and governments on human rights and the development of equitable health policies. He previously initiated and then led the International Development Law Organisation's Health Law Program, and he's worked for the United Nations Development Program and UNAIDS on law, health and human rights. He has extensive experience as an advocate working to use law to address HIV/AIDS around the world. Currently, he is a legal scholar with the Global Health Law Groningen Research Centre, where his research examines the use of human rights, including the right to health, to protect people's health in the planetary crisis. So David, please, the floor is yours. Yeah, and thank you. Got to speak from the podium. Oh, perfect. Thank you.
Okay. Thank you, Alex. Thank you all. What a rich panel. Goodness. I've got so much to say, so Alex, I'm going to rely on you to cut me off if I start going on for too long. So, so we had such a wealth of discussion this morning, and I'm speaking to you as someone with a legal background, but I'm aware that there are people here who don't have a legal background, but you come from the health sciences, the social sciences, and many other perspectives, civil society organizations. So when you're listening to what we're saying, thinking about where you can see yourself in this, because I think one of the opportunities for this conversation is for everyone to find themselves in there somewhere. And I'm particularly speaking to people who are working in civil society organizations and in the field and in the global south. So my comments, my reflections are actually from my own perspective, which is someone who's worked for many years in the HIV response. And so I'm going to go back a couple of decades and reflect on how the law was used to increase access to treatments in the context of HIV, but also picking up on what Professor Ip is suggesting is how we might look at the UN processes going forward in the context of climate change. In the early 1980s, there was another huge threat to global health, which was the HIV epidemic was spreading out of control. It was greater in the global south, as you know, and particularly among socio-economically disadvantaged populations and people stigmatized everywhere. If untreated, HIV infection led to AIDS, debilitating illness, and usually death after around 10 years, more or less after infection, leaving many thousands of orphans. I'm going to particularly talk about the situation in South Africa because that's been particularly well documented. Around the end of the 1990s, around a quarter of the general population of South Africa was HIV positive, and there was no accessible treatment. Later in the 1990s, effective treatments were more available in the global north, and they cost around $10,000 per person annually. Lower-priced generic drugs were available in some countries, but the major obstacle to accessing those drugs was the international patent law system, which obliged all WTO members, which included South Africa, which obstructed them from importing these generic drugs. This story may be familiar to some of you, it may not be familiar to others, but what's valuable about this story is the role of civil society in taking on this issue, because today we have a very different situation. No, but that response was driven by civil society organizations, not initially governments. However, in 1997, the South African government amended its legislation to permit access to these drugs, but they were immediately challenged in court by 45 of the most powerful international pharmaceutical companies from around the world. The AIDS Law Project, which came from the University of Witwatersrand in South Africa, combined with the Treatment Action Campaign, which was a civil society organization comprising people living with HIV and affected communities, joined the court action as a friend of the court. But most importantly, and this is really from a strategic litigation point of view, they mobilized thousands of people outside the courthouse, which attracted the world's media to that case in Pretoria. And they were demonstrating outside the court. So in 2001, stepping back and looking globally, 40 million people were living with HIV around the world. 5 million people were newly infected every year, and there were 3 million deaths from AIDS every year. There were protests globally, and around April 2001, those drug companies in South Africa, in the Pretoria court, walked out. They abandoned the case. So we didn't have a legal decision, but they were shamed, and they left because of the shame they had to face, nationally and internationally. It was a fantastic decision. And I remember Giovanni Mori's presentation on Wednesday, perhaps you remember it, the slide, and he said after the Paris Agreement, the uptick in strong NDC responses came when the street demonstrations grew. Fantastic. So we faced, back in the HIV response, there were two urgent challenges. One was to roll out the cheaper drugs, and the other was to stop more people getting infected. So we moved to the international stage, and we had a UN General Assembly special session on HIV. How many people here are aware of that event? A UN General Assembly special session on HIV. Okay, so out of that came the Declaration of Commitment to respond to HIV. It was adopted unanimously. It was a resolution of the UN General Assembly, and a monitoring framework and a process for accepting shadow reports from civil society to make sure governments were held accountable for their commitments in the monitoring framework. And we had the Global Fund to fight AIDS, tuberculosis, and malaria. That all came out of this UN General Assembly special session on HIV. And on the governing board of the Global Fund, there are civil society representation. It was a world first. So, yeah, 1 minute, okay, just to finish. So at the end of 2024, there were a drop, we still had a lot more infections. At the end of 2024, we have reduction of new infections. About 75% of people around the world were receiving treatments, and we had a vision of an end of AIDS as a global health threat. Of course, in the current context, we know with the funding cuts, we're still facing a lot of challenges. So the conclusions for the implication for global health. The inclusion of voices of affected communities is critical. Broad social mobilization is critical across multiple communities using the language of human rights. We have to ground our advocacy in science, as we did with the HIV advocacy. There is a risk of private sector obstruction, and we have to respond with legal action combined with social mobilization. And I invite you to consider, following Dr. Ip's broad view, why don't we have a UN General Assembly special session on planetary health? It would be come up with a rights-based resolution, an accountability mechanism, and engage civil societies at all levels in the monitoring. Thank you very much.
Thank you so much, David, for giving us that vision of what might be possible. I want to take this moment to say a huge thank you to our speakers and here and online. Thank you to our speakers online for joining at very odd hours. Very much appreciate it. And please stay tuned. The Johns Hopkins Institute for Planetary Health program is launching a new newsletter. That part of that newsletter is sharing these opportunities for input. So things like the general comments, and right now there is one from the UN Special Rapporteur looking around clean air that I can point you to those details as well. So thank you very much for coming today. Thank you for your questions, and thank you for an amazing
Alex.
panel.
Thank you so much.